questions directed at the arguments I have made.
So, sorry, before you conclude, I just want to sum up your point that you make in relation to the last sentence in section 47(1)(e). So you are saying, since the court imposed a sentence of 15 months, that imposition is what this court should work with, not the effect of the remission.
Yes.
And he will only qualify for National Assembly membership in terms of section 47(1), 5 years after that sentence has been completed.
Yes, which now means, because
wait. And my question to you is, when was the sentence completed? Because remember, and I invited you to explore the purpose of a sentence, right? And that consideration becomes relevant in determining when was the sentence completed.
So that's why I say that once you look at the last sentence, section 47(1)(e), it's completed. When you look at the first line, it's convicted and sentenced.
Yes.
So it's clear here that the intention is to focus on the actual period served. So if he leaves prison, it's the period served, which is you go to Smith, you go to Ohoshi, and then 5 years from that period, because we cannot say, well, he has completed it when he is in fact out of prison. So we submit that there is a possibility, if you look at that, to say the period was in fact completed when he left prison physically. But what you can never change is what was the sentence that was imposed on him.
So what sentence was completed, Mr. Ngcukaitobi? What is the sentence that was completed? Because we're trying to determine the date. What is the sentence that was completed?
Mr. Zuma, first, he did not complete his sentence. We know that it's a fact. So he never completed his sentence.
Why?
Because he was released initially on medical parole, which was declared unconstitutional, and secondly, he was released as part and parcel of the special remission. So he never completed his sentence.
But isn't the effect of the remission that when he reported back to Escort prison, and he was met with the news that the president has remitted his sentence. What that meant is that he had completed serving his sentence.
Well,
right? So that's the date. He had completed serving his sentence. Why must we ignore the period that he served? Because that was the sentence. The period he served is the sentence.
No, but that is just incorrect as a matter of fact and as a matter of law. The period that was imposed on Mr. Zuma is 15 months. It is not 3 months. The fact that he subsequently serves, and we're not asking this court to further punish Mr. Zuma, we're simply asking the court to make a declaration that the IEC was right when it found that he was excluded by virtue of section 47.
Okay, please answer this simple question. The last sentence reads, a disqualification under this paragraph ends 5 years after the sentence has been completed.
Yes.
In this scenario, in this case, what is that date?
What we know here on this fact is that Mr. Zuma, as a fact, was released from prison.
Yeah.
So, which means whatever the courts decided would be the correct sentence, which is the first part of the section, was interrupted by presidential decision. So, which meant that he left prison. But that is irrelevant to the point I'm making to the court, which is section 47(1)(e), the current position that Mr. Zuma was excluded because the judges had imposed a 15-month sentence. You cannot change that by simply saying that the president effectively imposed a different sentence.
No, please answer very... Sorry, I'm still... Yeah. Please answer... Okay. Answer a very simple question. if the IEC is faced with this question, if the IEC has to determine when does this 5-year period that is referred to in section 47(1)(e),
Yes.
when is that date? What's the answer?
Well, there are two answers to that question. The first question is, it would be the 5 years calculated from the judgment of the Constitutional Court. And that is also a viable answer to it. That's one. The second one is, it is the sentence actually served. And if
This section talks about completing a sentence. We're still in the 5 years. On your argument, we're still in the 5-year period, right? Is the sentence completed or not? On the present facts, is the sentence completed or not? You're saying it's not completed.
No, we know as a fact that Mr. Zuma received a remission, which meant that he had to leave prison. And so, if the correct construction of complete means physically leave prison, we know that that happened already after 3 months after he was in prison.
Physically and lawfully.
Well, this is a big debate about the lawful part, Justice.
Sorry, Justice Yacob. Yes.
Sorry.
I just want to, yes, can I just, I don't want to lose this point. I'm still waiting for that date. We're still in the 5-year period. Are you saying he's still serving a sentence?
No.
Are you saying the sentence is not completed?
No. Well,
When was it completed?
Justice Modiba, I think we're dealing with two different propositions.
Yes.
Let me try and get to where we are.
Yes.
Firstly, for purpose of section 47(1)(e),
Yeah.
my argument is simple. My argument is the section focuses on the date of the sentence that was imposed by the Constitutional Court.
Yes.
And from that premise, the sentence is 15 months, therefore he is disqualified. So we can put a full stop on that.
Yeah.
Yes. Now there is another theoretical possibility, which is when would the 5 years come into operation? Now to that I propose two answers. One answer is that 5 years would be the period actually served, which means it would be 5 years from the 3 months. That's one answer to the question. And so there's no inconsistency there between that and the first submission. The second one is, it is theoretically possible that the sentence that was imposed by the Constitutional Court, that the 5 years is calculated, that has nothing to do with whether or not Mr. Zuma...
It's calculated from when?
From the sentence imposed by the Constitutional Court. That has nothing to do with whether or not
I'm not with you. You're saying it's calculated from the sentence. I'm looking for a date. From the lapse of the sentence.
End or completion of the sentence.
So you calculate 15 months from the date of the imposition.
Not 15 months. Oh yes, 15 months from the date of imposition, yes. I was thinking about 5 years.
I'm trying to understand your submission.
So you're giving us 2 dates,
Yeah,
right?
so
it runs from the day he walked, or it runs from the day
Yes.
he would have completed serving the 15
Yes,
months.
so I say proposition 1 is it's 5 years calculated from the lapse of the 3 months.
The lapse of the 3 months or the lapse of the 15 months?
Of the 15 months. Now, those are the two propositions. Now, out of those propositions, we have to work out, firstly, what is their relationship with section 47(1)(e) and whether or not Mr. Zuma is currently eligible to stand. I say it has no relationship whatsoever. The second is, as a matter of sentencing law, what is the effect of that remission? The effect of that remission, we would say, obviously, has resulted in Mr. Zuma not serving any period. So that was the effect of it. It was that he would not serve the remainder of the period. But it was never to mean that a judge would not regard the finding and the sentence as not having been found and sentenced as per section 47(1)(e).
So you are saying we shouldn't be too concerned about the fact that he only served 3 months
Yes.
in prison. What we should be concerned with is that the highest court in this land
Yes.
found his conduct so serious that a sentence of 15 months imprisonment is appropriate. And because that sentence was imposed, he's then hit by the disqualification in section 47(1).
Indeed, and thank you for that summary, Madam. I was just trying to find the actual section. But that, in fact...
Sorry, Mr. Ngcuka, there's something that sort of bothers me here. I've just listened to the interaction between you and my sister regarding the construction of the last sentence in section 47(1)(e). Now, you've already told us that the disqualification ends 5 years after the sentence has been completed.
Yes.
But now we know for a fact that the sentence which Mr. Zuma completed was the 3-month sentence. Is that not so?
No, this is the point I was trying to
for
make.
all intents and purposes.
No, Justice.
Because on your construction, Mr. Zuma will never be able to qualify, to complete. That disqualification will never end, because there is no sentence which he completed. You understand
Justice.
my problem here?
No.
Yeah.
Then maybe I am wrong because I
No.
have expressed...
You're not wrong.
because maybe then I'm wrong in the way I've expressed myself.
Okay. Express yourself.
Let me correct you.
Yes.
So you start off with 15 months.
Yes.
That's the sentence imposed.
Yes.
Now, that sentence could be completed when Mr. Zuma actually completes 15 months. Correct? That's one. There's no problem. That sentence, which is 15 months, can also be completed in a period that is shorter than 15 months. For instance, by a remission. It's still completed because he is out of prison. It's still completed. For instance, by a remission or by another form, which could be an expungement, but it's still completed. In other words, he cannot go back to jail to serve the period. So it's not inconsistency to say you've got a period of 15 months, but you completed it in 3 months by virtue of a presidential act. So that's the proposition there. Now, we go back to what the argument is about, which is the argument we are dealing with today. And the point I was trying to make to Justice Mudib, what does Section 47(1)(e) deal with? It deals with two scenarios. Scenario one is where we are right now, which is the sentence imposed by the court. And does that mean that Mr. Zuma is precluded? The answer to that is yes.
That will be the sentence that will be reflected in ACP 69.
Precisely.
Okay.
And then it deals with the second scenario, which is that sentence remains, but you have completed it because there has been a presidential remission. You cannot return to prison. It's finished. There was never a sentence of 3 months in this case. There was always a sentence of 15 months. But he completed that sentence because the president, as a fact, released him from prison.
So, in other words, would you accept that the remission does have the legal effect
Yes.
on the sentence that is imposed?
No, on the sentence that is served. That is what I am arguing.
It has got a legal effect on the sentence that is served, not on the sentence that is imposed.
Yes, that fact never changes. It never changes at all. It always remains. That was the sentence imposed. And if he finishes that sentence in a period shorter than the actual sentence because of the remission, then he would qualify under the last sentence of Section 47(1)(e).
So the sentence that we look at for the purposes of the last sentence in Section 47(1)(e) is the 3-month sentence. Because that's a sentence that he completed. There is no other sentence that he completed.
No, my lord. The sentence is always 15 months because that was the sentence.
But for the purposes of the last sentence, because the last sentence determines the period of disqualification. The disqualification ends 5 years after the sentence has been completed. There can't be 2 sentences.
No, there's always, exactly my point, there's always one sentence. It's always 15 months. the 15 months could be completed because you have served it, but it could also be completed because there has been an executive act that reduces that sentence. The sentence is still 15 months, but you've completed that sentence because you've received a presidential pardon or you've received a presidential remission. But the legal fact remains you were convicted and sentenced to 15 months. That never changes. What may change is when we calculate, when did you complete this for the second part of section 47(1)(e), we would then say, well, you completed it earlier than the 15 months because you received a remission. And that is the point I was trying to make to Justice Modiba when I tried to say he will benefit from the remission, but that benefit will be 5 years from the time that he received that remission, because the effect of that remission was a completion of the sentence. The effect of the remission was never to change the sentence imposed.
I'd like to hear your response to the submission by Mr. He took us through several synonyms of the word remit, right? And the ones that remain in my mind is set aside, cancelled, and you have emphasized now in your submission the one synonym, reduced. Now, I'd like you to address me on the other synonyms, because if remit means set aside, and you'll recall the debate I had with him, whether his argument is that effectively the remission of Mr. Zuma's sentence by the president interfered with the sentence that was imposed by the Constitutional Court. And that would be so if the synonym set aside is the one that best describes what the president did, or cancelled best describes what the president did.
Yes. What we say that the leadership does not have to look at the dictionary for this, because there are judgments that deal with this. And Mr. Bofo has relied on the judgment of Smith, and the one I'm looking for is Smith, actually, at page 47, particularly paragraph 34, page 58 of their bundle of authorities. So if you look there, it doesn't use the word reduce, but it uses the word deduct. And so, which is closer to reduce. And so that's why I say to the court, so if you look at paragraph 34, page 58, it's a judgment, I think, of Straight or J. Yes. So out of those synonyms, the closest juridically is deduct or reduce, but not set aside. He has no power to set aside anything. He has the power to forgive, which has the consequence that the period that a prisoner spends in prison is reduced or deducted.
No, but what is being reduced? Because his powers as set out in section 84, is it section 84, 1J of the Constitution, to remit a sentence. So if you are saying when he remits, he deducts from a sentence, what does that mean?
Well, what it means is, in fact, if you look at the actual, it's interesting when you look at the proclamation itself.
Which proclamation?
The proclamation in this case. It's interesting that it actually never refers to the sentences effectively disappearing or evaporating. I just want to find...
Please refer me to the document.
Yes.
You've given us bundles.
That's 167.
Of the pleadings bundle.
Of the pleadings bundle.
167.
Start the Afrikaans version.
So 167.
Sorry, Madam, just 167, yes.
It's 167.
So what is interesting is that he actually never says the sentence changes from the sentence originally imposed. And what this is about really is regulating the remaining period of incarceration. So if you look at paragraph 1, 2, 3, 4, there's no 5, but 4, 6, 7, 8. So even when you look at the text of the actual instrument of the revision, it never supports what is contended for today. It simply is about the remaining part of the incarceration.
So you are saying the sentence imposed by the court remains? The remission only affects the period served? The period served in prison?
The period of the incarceration, that's the power of the president. So for purposes of section 47(1)(e), it's always the sentence that was imposed by the court that it should be taken into consideration. Because that's the correct sentence from a purposive perspective. Because that's what tells us what the court thought about the conduct of a particular individual. Your Lordship presiding, I'm not sure if I did answer your question, but it was a long way towards it. But I think finally at least I've answered it.
Yeah.
Sorry, Mr.
There's a question from my brother on the left.
If I may take you to your bundle, page 47, the Freedom Front judgment, page 15. Could you please take me through it? So the paragraph 15, that's on page 54.
Our authority is binding. What's the specific issue that I should deal with?
Paragraph 15.
Yes, I've heard you, my lord. But what exactly about paragraph 15?
It talks, that paragraph, the interpretation relates into that the period of the sentence should be completed for 47(1)(e) to be completed.
I'm terribly sorry, my lord. I still don't understand exactly what. I've got the section, I've got the paragraph. I just don't understand what the question is.
The question is, if we rely on the interpretation that the sentence for the purposes of 47(1)(e) should be served to full completion. In other words, there should be no interruption.
I've never suggested that it should be served to full completion and that will be no interruption. I have expressly said that the effect of the Presidential Act, and again, I mean, maybe it's me who didn't explain this properly. I've expressly said the effect of the Presidential Proclamation was never to undo the sentence imposed. What it did is that it rendered that sentence completed by operation of law because it meant that he could be released after 3 months. So, as a fact, it didn't complete it because he didn't serve the 15 months. But the president brought that completion forward because 3 months he released him. But section 47(1)(e) does not help us there because that section is about the sentence imposed by the courts, unless it has been overturned on appeal. So the issue around paragraph 15, I mean, I read that judgment. That judgment was about the wholly suspended sentence. That's why I thought it's irrelevant to this debate, because this is not a wholly suspended sentence we're dealing with. What Freedom Front Plus was arguing is that even though Mrs. Mandela was given a wholly suspended sentence, he should nevertheless be precluded by virtue of section 47(1)(e). And this court said no, it shouldn't be, and that the interpretation they were placing on the section was not supported by the text or the purpose of the section. This case stands on a different footing. This case is about a sentence actually imposed without option for fine, which makes it within the qualifying of section 47(1)(e). And again, I want to repeat this so that if Professor, you leave this room believing that my submission was that he should be serving the 15 months, that's just wrong. My submission was there are two ways of looking at completion. One way of looking at completion is to complete the entire sentence. Another way of looking at completion, which I submit the court should endorse, is that the sentencing means that the completion period, which is the period of service, is reduced because of the interference of the presidential remission. And that is why Mr. Zuma will in fact benefit from the last section of section 47(1)(e) within 5 years after the period of completion. And that period of completion will then be the period when the president released him from incarceration. And that still doesn't answer the primary issue before this court, which is what is the sentence imposed.
Thank you, Mr.
So you're saying because he said if he completed the sentence earlier by virtue of the remission, then the 5-year period will arrive earlier.
It will arrive earlier. That's the benefit of the 5-year period, because the completion is the actual release, it's the actual service. But he is prohibited. So the point I was trying to make is, I'm not suggesting that that remission will never bear any benefit to him. It will. He will get that a lot earlier than you otherwise would have.
Question? One question? Right, thank you, Mr. Ngcukaitobi. Thank you very much.
Hello?
You wanted to be excused.
Yes, I still want to be excused, although I'm not sure.